Let's start. A revisional application under Article 227 of the Constitution of India posed a question before the High Court Calcutta as to whether a party not being a party to an arbitration agreement should be included as a party thereto in an arbitration proceeding under Section 9 of the Arbitration and Conciliation Act 1996, which dealt with interim measures by the court for protection and custody of subject matter. An arbitration agreement, particularly when the City Court Calcutta passed an order for adding a third party as a party to such proceeding of this application under Order 1, Rule 10 of the Code of Civil Procedure 1908. The question for a decision is whether the order of the trial court needed any interference by the High Court on revision as an arbitration proceeding under Section 9 of the Arbitration and Conciliation Act 1996 being purely a temporary measure for giving custody of such matter of such proceeding was confined merely on matter coming within an arbitration agreement as defined in Section 7 of the Act. A party not coming within such agreement could not be a party of such an arbitration agreement. So, addition of such party in an arbitration proceeding under Section 9 of the Act would create complications unnecessarily by way of an unwarranted interference in such proceeding, which was purely for taking interim measures for protecting properties. The trial court therefore failed to exercise its jurisdiction appropriately, which needed interference by setting aside the order of such court para. This application is at the instance of the petitioner of a proceeding under Section 9 of the Arbitration and Conciliation Act 1996 and is directed against the order number 27 dated May 27, 2008 passed by the learned Judge City Civil Court at Calcutta in miscellaneous case number 1349 of 2005, thereby allowing an application under Order 1 Rule 10 of the Code of Civil Procedure filed by the opposite party number 3 pair. The short fact is that the petitioner filed the said proceeding for recovery of money advanced with regard to a motor vehicle. The opposite party number 1 is the hire purchaser and the opposite party number 2 is the grantor of the said transaction for non-payment of the money. The petitioner filed the said title suit praying for an award of rupees 3.57 lakh, declaration that the petitioner is the owner of the said motor vehicle, recovery of possession and other reliefs. During the pendency of the said proceedings under Section 9 of the Act of 1996, the applicant of the opposite party number 3 herein filed an application under Order 1, Rule 10 of the CPC contending inter alia. In fact, he is the owner of the said motor vehicle and he purchased the same upon taking a loan from the ICICI Bank. He has been paying the monthly installments to the said bank and as such he is the owner of the vehicle in question. Therefore, he should be added as a party to the proceeding that the application was allowed by the impugned order. Being aggrieved, the petitioner has prepared this revisional application para. The learned advocate appearing on behalf of the petitioner submitted that the proceeding under Section 9 of the Arbitration and Conciliation Act 1996 was initiated that taking interim measures with regard to the subject matter of the property in dispute. Since the proceeding has been instituted under the Special Act, the parties to the suit should be as per terms of the arbitration agreement held between the parties. He has referred to the definition of party as per Section 2 within bracket small h of the Act of 1996. The arbitration agreement has also been defined in Section 2 within bracket small b of the said Act of 1996 and the Section 7 of the said Act lays down what is the arbitration agreement. Therefore, according to such provisions of the Special Act, the applicant is neither a necessary party nor a proper party to the arbitration proceedings, so the learned trial judge has committed a wrong in allowing the application under Order 1 Rule 10 of the CPC. It must be set aside para. On the other hand, the learned advocate appearing on behalf of the opposite party submits that it is the applicant opposite party number 3 here in bank and the applicant has been paying the monthly installments as per the agreement with the bank. He has almost cleared up the dues to the bank and as such he is the owner of the vehicle in question. Therefore, the applicant has an interest in the vehicle in question, so the learned trial judge was justified in allowing the application under Order 1 Rule 10 of the CPC. So the application under Article 227 of the Constitution should be dismissed. Therefore, the point that the charges for decision in this application whether the impugned order would be sustained. Upon hearing the learned counsel for the parties and on going through the materials on record, I find that the subject matter of the proceeding under Section 9 of the Act of 1996 relates to a vehicle bearing registration number JH10E2958. The plaintiff initiated the said proceeding for recovery of money and other reliefs contention inter alia that the vehicle in question was laid out on hire by the petitioner to the opposite party number 1 under a hire purchase agreement in writing dated May 31st, 2004. The opposite party number 2 is the grantor of the transaction according to the contention of the petitioner. Thus, I find that in a proceeding under Section 9 of the Act of 1996, the party as defined in Section 2 within bracket small h of the said Act has been made the party to the proceeding. Section 2 within bracket small d of the said Act defines what is arbitration agreement, and Section 7 of the said Act lays down elaborately the mode of creation of an arbitration agreement and the form the agreement. Thus, I find that according to the definition of the arbitration agreement as per Section 7 of the said Act of 1996, the parties have been framed in the proceeding under Section 9 of the Act of 1996. Now, Section 9 of the Act of 1996 lays down the provision for passing interim order if the situation demands on urgent basis relating to protection, preservation, and maintenance of the subject matter of the proceeding. This is a purely temporary measure meant for giving custody of the subject matter of the proceeding. The ultimate decision will be taken by the arbitral proceeding according to the terms of the arbitration agreement. Since the matter relates to a pure arbitration agreement, it should be confined within the parties to the arbitration agreement panel. The applicant of the opposite party number 3 herein was not at all a party to the said arbitration agreement, and so his status with regard to the arbitration agreement is nothing but a third party show in a dispute between the parties to the arbitration agreement. If he is added, it will unnecessarily create widening the scope of the dispute relating to the question of title over the subject matter of the proceeding amongst the parties to the proceeding. I have stated earlier that the proceeding under Section 9 of the Act of 1996 is purely for taking interim measures for protection over the subject matter of the arbitration agreement, and in order to take such measures, the presence of the applicant of the opposite party number 3 herein is not at all necessary at the time of hearing of the said proceeding. The decision in the case of Sushil Pal versus HDFC Bank Limited and others in an unreported case of FMAT number 681 of 2006 within bracket 1 of the Honorable Division Benches of this Honorable Court has observed that the applicant need not add it as a party to the arbitration proceeding. This was also followed by another Honorable Single Judge within bracket Justice S.P. Talukdar as his lordship there was in CO number 4238 of 2006. It was also followed by another Honorable Single Judge within bracket Honorable Justice S.K. Mukherjee in an unreported case being CO number 1493 of 2001. These decisions are very much in consonance with the present case. Therefore, I am of the view that the applicant is neither a necessary party nor a proper to the proceeding under Section 9 of the Act of 1996. The contention of the opposite party number 3 is that he had purchased the vehicle in question after taking a loan from the ICICI Bank, and he has repaid a considerable amount to the bank. He has become the owner of the vehicle in question, so he has got an interest in the vehicle in question, so he should be implemented as a party to the proceeding under Section 9 of the said Act of 1996. In this regard, upon due consideration of the matter in dispute between the parties to the arbitration proceeding, I am of the view that whatever the interest the opposite party number 3 may acquire in the vehicle in question, since he is not a party to the arbitration agreement, he should not be implemented as an opposite party in the said proceeding. If the opposite party number 3 has acquired any interest in the vehicle in question, he has independent right over the vehicle in question and he can take the necessary steps by institution of an appropriate proceeding. If he is advised to do so in accordance with law, so the opposite party number 3 is at liberty to take appropriate steps for starting other proceedings should case if he is advised to do so in accordance with law, but he has no right to interfere in a proceeding under Section 9 of the Act, which is purely interim in nature for the protection and custody of the subject matter of the arbitration agreement. For that reason, he need not be pleaded as a party to the arbitration proceeding better. In view of what has been observed above, I am of the view that the learned trial judge has failed to exercise the jurisdiction vested in him and that he has committed errors of law in allowing the application under Order 1, Rule 10 of the CPC by the impugned order. Well, accordingly, the order impugned is not sustainable, so the application succeeds. The impugned order is hereby set aside. Well, the application under Order 1, Rule 10 of the CPC filed by the opposite party number 3, June 6, 2007 stands rejected. The application is allowed in the manner as indicated above. Considering the circumstances, there will be no order as to costs. Stop. Thank you. Jai Hind. Jai Mera Bharat. Party in the said proceeding. If the opposite party number 3 has acquired any interest in the vehicle in question, he has independent right over the vehicle in question and he can take the necessary steps by institution of an appropriate proceeding. If he is advised to do so in accordance with law, so the opposite party number 3 is at liberty to take appropriate steps for starting other proceedings should case if he is advised to do so in accordance with law, but he has no right to interfere in a proceeding under Section 9 of the Act, which is purely interim in nature for the protection and custody of the subject matter of the arbitration agreement. For that reason, he need not be pleaded as a party to the arbitration proceeding better. In view of what has been observed above, I am of the view that the learned trial judge has failed to exercise the jurisdiction vested in him and that he has committed errors of law in allowing the application under Order 1, Rule 10 of the CPC by the impugned order. Well, accordingly, the order impugned is not sustainable, so the application succeeds. The impugned order is hereby set aside. Well, the application under Order 1, Rule 10 of the CPC filed by the opposite party number 3, June 6, 2007 stands rejected. The application is allowed in the manner as indicated above. Considering the circumstances, there will be no order as to costs. Stop. Thank you. Jai Hind. Jai Mera Bharat. Is allowed in the manner as indicated above. Considering the circumstances, there will be no order as to costs. Stop. Thank you. Jai Hind. Jai Mera Bharat. Hind. Jai Mera Bharat.